Live and has created more people with opinions than ever before. However, with the number of social media influencers and content creators increasing on a daily basis, more and more people run the risk of criminal and civil liability for their online activities. My next guest says the risks faced by people posting on social media could range from unintentional copyright infringement to defamation and even criminal injury. Johannes du Plessis is a legal advisor at Risk Benefit Solution RBS, and he joins us this morning from our studios in Sea Point in Cape Town. Johannes, good morning to you. Thank you so much for coming through.
Morning. Thank you very much.
Now, social media has certainly taken over the world. We do know that. But talk to us about things that one should consider before putting up that post on social media.
Yes. Persons on risk include social media users, content creators, influencers, business reviewers, and even spectators at live events that record these events and post it on social media. Now, risks for these people include copyright infringement, distribution right infringement, broadcasting right infringement, civil liability, defamation, and even criminal liability. With regards to the copyright infringement, spectators at these live events record very frequently these events and repost it on social media, and it's viewed by other social media users. But these events are many times subject to copyrights and distribution and broadcasting rights. And what they must remember is that copyrights means that the hosts of the events and the creators of the events have the sole right to record and copy those events. And also distribution and broadcasting rights means that the television program and radio programs have the sole right to distribute and broadcast those events. And actually posting these events on social media of these recordings can then infringe those copyrights, distribution rights and broadcasting rights, and the social media user can be held liable for it. And civil liability can...
No, I wanted to ask us to...
Civil liability can include...
All right, sorry, go ahead. You can go ahead.
Please go ahead.
No, it's fine. You can go ahead.
Okay. Thank you. So civil liability includes the damages that the broadcaster then suffers as a result of the infringement, and the broadcaster and the content, the owner of the copyrights can then hold the social media user liable for that, those damages.
All right, but what's the safest way to do it? Do you perhaps credit the original author? What's the safest way to do it?
So the safest way to do it is just for a social media user not to copy those material and not to repost it, and to be very careful not to repost those videos and recordings, and to be careful not to record that in the first place if it might be subject to copyrights and distribution rights and broadcasting rights, because it actually does cause damages to the owners of the copyrights and distribution rights and broadcasting rights.
All right, so the safest way is not to even do it at all. You don't even have to credit the original author of the post or of the information, so don't do it at all.
Yes, it's safest not to do it at all. If you do it, it's best to obtain the permission of the rightful owners of those material, because it's many times that the rightful owners that pay compensation for those rights, and merely just citing them would not be sufficient. So it would be sufficient more to just obtain their permission first.
But are the different social media companies or houses also have precautionary measures in place? Because I do know that on Facebook you can never go live on Facebook whereas there is a song playing on the background. Are they doing enough as well to protect such?
So with regards to the social media platforms, the Section 75 of the Electronic Communications and Transactions Act actually limits the liability of these social media platforms. And it says that these social media platforms, even though that they provide the ability for social media users to live stream these events and repost videos of events that might be subject to copyright and distribution right and broadcasting rights, that in terms of this legislation, the social media platform's liability is limited, and the liability actually rests solely on the social media user, and the social media user can then be financially ruined by the liability if it solely rests on the social media user alone.
All right, so it goes back to the users themselves. You keep referring to social media influencers and content creators. Talk to us about the difference between the two.
So, social media influencers are persons who influence the public through social media, and content creators are persons who create the contents for articles and also for example, record information and reposts it. So many social media users are influencers and business reviewers and content creators. So for example, if you take into account the business review, if a business reviewer goes online and reviews a business, they must just keep in mind that a business has a right to a good name, status and reputation, just like any other person. And infringing the right to a business's right of a good name and reputation actually is called defamation, and a social media user can be held liable for that kind of damages.
All right, but what happens if I post something unintentionally and it infringes on someone else's copyright? What happens in such a case?
So in terms of case law, it is still sufficient to be held liable if it was done unintentionally or accidentally. So then you would be held liable for negligence. So the court actually held that intention is not required to be held liable here for. And in terms of wrongfulness, the court actually deems a social media user or a person who had made a statement that defames another person to be wrongful until otherwise proven. So in terms of defamation, the onus is shifted from the person who claims or from the business onto the social media user. And the social media user then finds himself in a situation where he has to prove that it was not done wrongfully and not done intentionally, instead of the business that has to prove that. And then even though if they still prove that it was done unintentionally, still they can be held liable for unintentional defamation by way of negligence.
Well, thank you so much, Johannes, for educating us about these. Quite an eye-opener. Thank you so much indeed for coming through and compliment van die nuwe jaar.
Thank you so much.
Thank you. Johannes du Plessis is a legal advisor at Risk Benefit Solution RBS, talking to us about what you should take into consideration before putting that post on social media.